Tribunal.
Judges from Britain, America, Russia, and France assemble in Nuremberg's courthouse. Empowered to impose sentence of death, or such punishment as it may consider just, the tribunal sits in judgment upon 20 leaders of the Nazi Party. After a first day spent in reading the 30,000-word indictment, the unemotional tones of Lord Justice Lawrence, President of the Court, open the second day's proceedings.
On Thursday, the 18th of October, 1945, in Berlin, the indictment was lodged with the tribunal, and a copy of that indictment in the German language has been furnished to each defendant and has been in his possession for more than 30 days.
So begins the case of humanity against the makers of war.
The defendants to plead guilty or not guilty to the charges against them. Hermann Wilhelm Göring.
Thinner, and without the notorious medals, the once mighty Nazi number 2 still postures in the limelight. While he waited in the dock, he wrote a statement which he tried to read before entering his plea. He said, "Before I answer the question whether I am guilty or not guilty," and that was as far as he got.
Bevor ich die Frage des Gerichtshofes beantworte, ob ich mich schuldig oder nicht schuldig bekenne,
I informed the court that defendants were not entitled to make a statement. You must plead guilty or not guilty.
bekenne mich im Sinne der Anklage nicht schuldig.
Furious, the one-time Reichsmarshal shouts, "I declare myself not guilty."
Well, good morning, America. This is Stuart Ryan once again with the Ryan Report. I've taken about a week's hiatus from putting out these podcasts as I believe I needed a rest from the amount of negative information shoved forward each day. And for today, I want to discuss the Nuremberg trials, the justice trials of Nuremberg, and our own SCOTUS potential trials for the Majority Six Nazis in robes who have destroyed this country's laws. Call me a cockeyed optimist, but I wanted to explore a demented and desperate vision I have about what must take place should we ever crawl out from under our nightmare loss of freedoms, the rule of law, and a constitutional obliteration. For guidance, I wanted to focus on our SCOTUS Nazi Majority Six, who are in large part responsible for this present Nazi regime, and I first looked to the Nuremberg trials to serve as a precedent, as it were, for potential trials of our own jurists who have undoubtedly betrayed our country. When I first began researching what I had understood to be the Nuremberg trial, I didn't realize there were actually some 12 separate trials in all, and not one special prosecution. And indeed, trial number 3 was known as the judge's trial, or as the justice trial. And that's what caught my attention, in which judges of the Third Reich were brought to account for their cooperation and participation in the Nazi march into a Hitlerian dictatorship and extremes of mass murder. In what became called the jurors' trial, surviving high-ranking jurists and prosecutors stood accused of, and I quote, judicial murder and other atrocities which they committed by destroying law and justice in Germany, and then utilizing the emptied forms of legal process for the persecution, enslavement, and extermination on a large scale, unquote. Is this process not similar to our own circumstances, less, of course, the extermination factor? Now, this judge's trial, or justice trial, was officially the United States of America versus Joseph Altstatter et al. And as I said, it was the third of 12 trials for war crimes the U.S. authorities held in their occupation zone in Germany in Nuremberg after the end of World War II. These 12 trials were all held before U.S. military courts, not before the International Military Tribunal, but took place in the same rooms at the Palace of Justice. The 12 U.S. trials are collectively known as the subsequent Nuremberg trials, or more formally, as the trials of war criminals before the Nuremberg Military Tribunals, NMT. The defendants in this case were 16 German jurists and lawyers. 9 had been officials of the Reich Ministry of Justice, which is comparable to our now DOJ, which is also a Ministry of Justice in the hands of the executive. The others were prosecutors and judges of the special courts and people's courts of Nazi Germany. They were, among other charges, held responsible for implementing and furthering the Nazi racial purity program through the eugenic and racial laws. In describing the crimes of the judicial system, one of our prosecutors, Telford Taylor, remarked, and I quote, "The dagger of the assassin was concealed beneath the robe of the jurist." Is this not true for the Majority Six conspirators of our own SCOTUS? Now, although the Nazi judges' involvement and responsibility for Nazi crimes against both the German people and humanity at large was predicated on very particular and devastating violations of national and international laws, they do, nonetheless, serve as a legal precedent for my proposition that if and when we restore our constitutional republic, then these 6 traitors, and I name them Amy Coney Barrett, John Roberts, Neil Gorsuch, Clarence Thomas, Brett Kavanaugh, and Samuel Alito, are brought to justice. They are arrested, prosecuted, tried before a jury of their peers if possible, and severely punished for their part in enabling and legalizing the establishment of an American dictatorship and Nazification of America in direct violation of their solemn oaths to uphold our Constitution, while, of course, misusing and abusing their extraordinary powers to decimate the foundational principles of our Constitution, our Bill of Rights, and all of the supporting federal rules, regulations, and strict laws that follow from that. And yes, I am fully aware that the term treason as described and interpreted in our federal laws and Constitution, is, unfortunately, quite narrowly defined, I would argue for a broader reading of its meaning. But let's leave that to one side. Although it must be said that if the criminal actions of the named justices does not equate to an act of treason, then what can? Now, while I am not comparing the consequential atrocities of the Nazi judges to our 6 justices' perfidious behaviors that has legalized one-man rule and a king who is above the law, completely absolving him from any possible criminal prosecutions for a variety of crimes that he has already committed and those he has currently committed, I'm exploring the principles laid down in national and international law established in the Nuremberg Trials that members of a judiciary can be held to account for their conspiracy, their actions, and participation in unconstitutional and unlawful decimation of the rule of law as set forth within said Constitution and federal laws as named parties to a judicial conspiracy turning America into a Nazi-like Christian nationalist white supremacist state of authoritarian one-man rule, threatening and destroying the absolute and the enshrined rights of all American citizens. Mere impeachments would never be enough to adequately address or to obtain redress for the evils that these named judicial officials have done to our 250-year-old democratic republic, overturning and perverting our framers' Constitution while following an extreme right-wing ideological agenda promulgated by Project 2025, the Heritage Foundation, and the Federalist Society, as well as other unnamed co-conspirators, in order to establish authoritarian rule in America, with a king at its control who is free forever from prosecution for crimes he commits while in power. Besides, moreover, Article 1, Section 3, Clause 7 of our Constitution does provide that the sanctions for an impeached and convicted individual are limited to removal from office and potentially a bar from holding future office, but an impeachment proceeding does not preclude criminal liability, although our Majority Six Nazi justices have just ruled that Trump is absolutely immune from prosecution in their deplorable repudiation of our Constitution and specifically Article 1, Section 3, Clause 7. Impeachments have rarely ever worked in American history, as it remains a political process relying on the House and Senate members to overcome their party affiliations in order to get a 2/3 majority conviction. Although at least 8 federal judges have been impeached and removed by the Senate, one example being Judge G. Thomas Porteous, who was removed in 2010. But Supreme Court justices can be charged with crimes, as they are not immune from criminal liability, but they can only be removed from office through impeachment and conviction. While they can be accused and even found guilty of a crime, a criminal sentence would not automatically remove them from their Supreme Court seat. Isn't that peculiar? The only way to remove a justice is by a majority vote in the House of Representatives to impeach, followed by yada yada yada, by a 2/3 vote in the Senate to convict. Problem. Then there is the matter of what we call judicial immunity against civil liability while acting in their official capacities, upon which the Majority Six might rely in their defense of any charges brought. And of course, there is the question of who actually prosecutes the case and who serves as judicial authorities trying the case and deciding the outcomes as finder of fact and law. Will it be a restored Justice Department? Or a specially convened military tribunal? Or a special Article III court? Will there be a jury trial or a bench trial? How will the verdict get appealed, if at all, and to whom? Finally, we come to the crimes that these named 6 High Court jurists committed. Crimes against the United States include treason, defined by the Constitution as, quote, levying war or adhering to their enemies, and other serial offenses like terrorism, fraud against the government, and conspiracy. These crimes are distinct from state-level offenses and involve actions that directly harm the authority, security, or property of the federal government itself. Accordingly, these 6 are also guilty of malfeasance in office. But let's just take one of the statutes that might be applied, because that is 923, 18 U.S.C. Section 371, conspiracy to defraud the United States. The general conspiracy statute 18 U.S.C. Section 371 creates an offense if 2 or more persons conspire either to commit any offense against the United States or to defraud the United States or any agency thereof in any manner for any purpose. The operative language is the so-called defraud clause. That prohibits conspiracies to defraud the United States, and this clause creates a separate offense from the offense clause in Section 371. Both offenses require the traditional elements of Section 371 conspiracy, including an illegal agreement, criminal intent, and proof of an overt act. And so, come to it, though it would be incredibly difficult to bring charges against these Nazis in robes, the 6 that I have named, who have led us directly into authoritarian rule, it must be done, even if we have to invent the legal process in which it is carried forth. That would be my hope, my dream, that we crawl out from under the mountainous hill and see the light once again, and that justice be done. Thank you for watching.